Well, good morning, everyone. Good morning on this rainy, what is it? What is today? Thursday. I'm losing track of time. My name is Elena Falcone. I am the Director of Public Innovation and Engagement at the Westchester Library System. I am also proud to say I am a co-chair of the Senior Law Day Collaborative. I share that role with attorneys Sarah Steckler of Keenan Bean and Melinda Bellis of Legal Services of Hudson Valley. You see their smiling faces in front of you. Joining us today is also our marketing consultant, Bruce Siegel of Marketing Sense, and today's presenter has managed to connect despite the rain, Salvotore Di Costanzo. He's a partner of Maker, Fragale, and Di Costanzo. And I'm just delighted that we're able to get yet another webinar going today, a live webinar where we get to answer questions from all of you and share some really important information. Before we start, I want to let you know a few things about the Senior Law Day Collaborative. The collaborative is composed of more than 160 professionals who are all eager to bring authoritative information on legal, financial, and health topics to our county's older adults, especially in these challenging times. The collaborative has been active in the county for more than 20 years, so I'm hoping this is not the first time that you've encountered us. We have a website that we have up on the screen that I wanted to be able to show you. I guess this is the thing that librarians always do. They're excited to show websites. The website you'll see across the top of the screen, the top of the site, seniorlawday.info, has some helpful navigation tools. I want to particularly call out that there's a calendar that will connect you to all of our events throughout the year. Hopefully some of them will be live towards the end of the year, but right now we're really happy to offer a roster of webinars. So even a pandemic is not going to stop us from getting information out. I also want to point out that we have the Elder Law Q&A, our sort of signature reference for all of you, posted in full text on this site. And in fact, it's kind of a reference for some of the information that you're going to hear today. If you go to this site, you'll see that there are chapters addressing all of these different topics, as well as a very helpful appendix of forms that you may need to complete. And the third thing I want to call out is that we have an Ask Us button here. The thing I want you to sort of leave this program with, aside from being terribly impressed by all the good information that you can get, is that you can always ask us a question. We'll have an opportunity for Q&A today, but also after today, a question's going to emerge. And you can simply click on this button and you can ask us your question. We'll respond to you within 2 business days, if not sooner. And we will even give you a call back if you like. You just have to put your phone number in. And what we'll do is then turn to the expertise of our more than 160 participating professionals to get you an answer to that question. If we haven't got the answer in our back pocket, we definitely know who does. There is a Q&A box for those of you who are connecting via the internet. There's a Q&A option at the bottom of your screen. You can feel free to ask us a question during the course of the presentation. We may not get to all of them in the context of this 1 hour that we have together, but we will follow up with you. Unless you happen to ask the question anonymously, then we won't be able to have a connection to your email address. Finally, you'll also see a chat box, and that chat box is one where you can ping Bruce or I or others to be able to get some tech support if for some reason you're not able to connect or you lose your connection. Just a heads up, it's raining. Internet connections tend to be wonky. Many of you are on phone. Please make sure that you are muted. And with that, Sal, take it away. Tell us about Elder Law 101, everything families need to know about preserving their assets.
Okay, thank you. So I first want to thank everybody for asking me to participate. This is an excellent, agenda, and what you guys do on a regular basis all year long is just, it's very helpful to the seniors in the community. And I've had the opportunity to participate on several occasions throughout the years, and I've always found it to be, very productive and very meaningful to the people that are listening. So thank you. I also have been starting out all of my lectures over the last month with a brief thank you to all of those out there that are helping us. The nurses, the doctors, the pharmacists, the staff in the hospitals, the truck drivers delivering supplies, the supermarkets, everybody that's out there trying to help us. We've all been affected by this virus in some way, shape, or form. I unfortunately have lost a family member. I know people on this call have probably lost, family members, and we all know somebody that's been affected. And we cannot go without showing our gratitude and our appreciation for those people out there that are on the front lines. So from the bottom of my heart, thank you. And for all of you people that are listening, stay safe. Protect yourself, do what needs to be done. Hopefully we'll be back before too long to some sort of sense of normalcy. And we're all looking forward to that, both from a familial purpose and a business purpose. And so I am an elder law attorney and estate planning attorney in Westchester County. I am also an accountant. So I'm going to give you the typical, what I call dog and pony show, that a lot of people are always asking for and are sometimes very confused or afraid to ask questions of attorneys. And a lot of these things that we're going to speak about are sometimes overlooked by people, right? So I speak from my heart. I speak from a very candid perspective. Generally speaking, when I do speak, I don't use slides because I want you to pay attention to me. I find that you do pay attention when you're not looking at slideshows. I find that I can answer your questions if you ask them. And if I can't answer them, I'll tell you. But what I'm about to speak about, I want you to really try to pay attention and implement, right? So too often we see people listening to our lectures and getting such good information and then not doing anything with it, right? And that's not good. So we're here today to give you a framework for what you need to be considering. And I'm going to tie in estate planning, Medicaid planning, some of the recent changes in the laws from a Medicaid planning perspective, which I bet most of you don't even know about. We're still trying to navigate the changes. And then also, I want to spend some time trying to educate you as to how we can go about implementing an estate plan during this crisis, right? These are very important topics. So let's start off with, what are some of the documents, whether they're basic or not, what are some of the documents that you need? People come to me all the time and they say, Sal, I want to put my affairs in order. And they really don't know necessarily what they're talking about. So I want to start with some things that are very basic, but are overlooked. Let's start with a power of attorney. So many people have powers of attorney. So many people do not have powers of attorney. A power of attorney is, no pun intended, extremely powerful document. But in our practice, we see very often that it's improperly drafted. It's deficient. What do I mean by that? And you're going to hear me say that often. What do I mean? What does this mean? Because attorneys have a habit of just of saying things, but not necessarily explaining what it means. A power of attorney is an instrument that allows you to appoint an agent to make financial decisions on your behalf. Now, the power of attorney is effective immediately upon signing. It dies with you. So a lot of people don't realize that a power of attorney dies when you die. The agent loses his or her powers upon your death. The purpose, though, of a power of attorney is that it's there, it survives your incapacity. So you sign a power of attorney today, it's effective today. You're appointing me as, I shouldn't use that as an example. People think that, that I really mean that, but you're appointing your spouse or your kids as the agent. If you have a stroke, if you have a heart attack, if you have some other disability that takes away your capacity, that person can handle your finances. That's extremely important, but that's every power of attorney. A properly drafted power of attorney needs to be modified. Now, what do I mean by that? If you have a power of attorney that you obtained off the internet, or you maybe were working with a general practitioner attorney, you're going to hear me say that often. The time has long passed where the things that we're talking about as elder law attorneys should be drafted by non-elder law attorneys. And a power of attorney is a perfect example. I'm not knocking general practitioner attorneys. We have a lot of friends that are general practitioner attorneys. But this area of practice has become so complicated that it's really taken the place of like a family law attorney. So if you can remember back in the days when somebody would come to the house and notarize something, and they would draft you a will, or they would, and if there was any issue in the family, you would ask the family attorney, the guy down the street. Well, that guy down the street has now really become an elder law attorney. It's gotten so complicated and so dangerous to not work with an elder law attorney that I can only illustrate that by talking now about a power of attorney. So a basic form of a power of attorney gives very basic powers: the power to write checks out, the power to handle your real estate, the power to deal with estate transactions. But that form is deficient in that it does not allow powers that we need as elder law attorneys to help you plan in advance someday later on. So for instance, there's something called a statutory gifts rider. Many of you have seen this. You have the power of attorney is in essence two forms. It's a power of attorney that contains all the administrative powers, and a statutory gifts rider that contains the powers to move your assets out of your name or to change beneficiary designations. Anything that changes your beneficial interest in an asset has got to be in the statutory gifts rider. A lot of people don't realize this. This just came up this morning in my practice. The statute talks about administrative powers like what? Administrative powers: writing out a check, paying bills, handling real estate transactions. Then we modify that as elder law attorneys, and we put things in there like the power to create a trust, the power to file Medicaid applications and do Medicaid planning, the power to retain a professional like an attorney or geriatric care manager. Those are all administrative powers that we put into the form that you don't see. The basic form does not have that. You only get that when you work with an elder law attorney. And those powers can be extremely important someday. The statutory gifts rider we modify to put gift-giving powers, unlimited gifting abilities. So your agent can move your assets around. You might have an annuity. You might have a brokerage account. You might have IRAs, life insurance. That statutory gifts rider has to be a part of your power of attorney, and it has to be properly modified so so that way the agent can do all these different things. Now, what does that mean? You might say, Sal, why in God's name would I want to give my kids the ability to move my assets out of my name? You can't look at it from the perspective of just simply moving assets out of your name. For instance, what if you get sick? What if you need home care? What if you need nursing home care? And we want to apply for Medicaid, because as you'll hear me talk later on, Medicaid is one of the primary options today to pay for this type of care. If we want to go down that road, we've got to move the assets out of your name, whether we're moving them to a spouse or to a trust or to a child or whatever the case may be. And there's all different kinds of rules as to whether we can do it or not, et cetera. But we don't even get to the Medicaid rules until I have the power to be able to move your assets. That's why you need a statutory gifts rider, and it has to be modified by an elder law attorney so that it has all the bells and whistles that we see on a regular basis. That's a pretty intricate document. It's what people would consider to be a basic document, but I would have to say a good majority of the people that come into my office, and I bet you a lot of you people that are listening to this right now, don't have a properly drafted power of attorney. So you want to make sure that's one of the first things you do. When I lecture, I tell people, even if you're afraid to work with an elder law attorney, even if you're afraid to put together your estate plan, even if you don't want to spend the money to do all this, because by the way, this stuff costs money, at least draft a power of attorney that's properly drafted. You'll be happy that you did. Your kids will thank you later on down the road. Another basic document is the healthcare proxy. I don't spend a lot of time talking about the healthcare proxy because it is actually quite basic. The healthcare proxy appoints somebody to make medical decisions on your behalf. It is somewhat of a pretty boilerplate form that you can get off the internet. We draft them. You don't need to get too creative. And quite frankly, our office does not get creative with healthcare proxies. The healthcare proxy under the statute simply needs to say, I appoint so-and-so to make my medical decisions. He or she knows my wishes regarding artificial nutrition, hydration, and that's it. the way we operate is we tell you now to have a conversation, a heart-to-heart with your agent under the healthcare proxy. Tell them what your wishes are. Make sure everybody understands what your wishes are. But don't get into all that ambiguity in your healthcare proxy. A healthcare proxy so often starts off by saying, and mine doesn't do this, but I see it all the time. If I'm in a vegetative condition, if I have no meaningful quality of life, if, you know what? Many of you probably already know you can't predict your long-term care needs. And these terms are very ambiguous. Meaningful quality of life, vegetative condition. I've seen people get into a healthcare proxy and start putting time frames that they may be incapacitated. And I have a very funny story. It's funny because it worked out. You know, the person survived, but he was in a coma, incapacitated, which turned out to be a pretty short period of time. But he had a healthcare proxy that actually had a finite date that the physicians were supposed to withhold life-sustaining treatment, and he was receiving some of that, and he, thank God, came out of the coma before he reached that date certain. And when we were all, and I didn't draft this, but when we were all said and done, I said, what would have happened if you were still incapacitated as of that date in time? You know, so I really encourage people not to put time frames on healthcare proxies, not to get very specific. Medicine changes, science and technology changes. Just draft a basic healthcare proxy that appoints somebody to make your medical decisions and leave it at that. So those are what we call your advanced directives. And that's what I would consider to be basic documents. There's other advanced directives, such as burial remains forms, if you have special requests regarding burial remains, HIPAA forms, if you wanted to do things like that. But those in large part are considered advanced directives, very basic. And a lot of people don't have them. And that's why I'm stressing about this. Very important documents. You know, we can use this virus to illustrate the importance of having those documents if you end up in a hospital setting. I have a few calls that came in over the last couple of weeks where I can't help people because they're in hospitals or they're in nursing homes. We can't get access to those people. The facilities are not willing to participate in a remote signing session. The family members can't go and visit. So I can't draft powers of attorney for people that have their capacity. I just can't get access to these people. And now if something goes wrong, we've got a problem. So very, very important topics. The next topic would be a last will and testament and or a revocable trust. Now, I believe that everybody should have a last will and testament, even if you think you don't need one. Things come up when you pass. You'd be surprised how there are issues that pop up, undeposited checks, refunds from certain organizations. You want to make sure that you have a last will and testament, even if you think your assets don't need to go through probate. So let's talk. What does probate mean? Probate is the process of taking your last will and testament after you die, and clearly you're not taking it to the courts, somebody else is, and going through the process of making sure that the will is valid, and if the court is satisfied that all formalities have been followed, appointing the executor that you have nominated in your last will and testament. That's the probate process. Matter of fact, the word probate comes from the Latin word probato, which means to prove. So probate is the process of proving the validity of your will. That's what probate means. Many of you have probably been through probate. Probate could take quite a while, several months. It could open up a forum for people to contest. It could be unduly burdensome, depending on what your estate looks like, because the courts are the courts, and the courts have, you know, certain rules and requirements that need to be followed. There are statutes that need to be followed, but that's probate. What needs to be probated? So when you pass, Let's say you have a house. Let's say you have a brokerage account with Fidelity. Let's say you have an IRA and a life insurance policy. Your life insurance policy has a beneficiary, or should have a beneficiary designation. So, number one, if you have assets that have beneficiary designations, please go home and check that you actually have beneficiary designations. So many people don't take the time because maybe you're relying on a financial advisor, not to draft beneficiary designations. You may have an account or a policy. You may have a beneficiary designation that's outdated. Please check your beneficiary designations. This is estate planning 101, but it turns into a mess when you die if you don't have beneficiary designations. Your IRA, same thing, beneficiary designations. Now, I'm not going to get into this today. It's more complicated, but under the Secure Act, which was recently signed on December 24th, or sometime around there by President Trump, it changes the rules regarding IRA distributions to beneficiaries. And also, it changes the rules on required minimum distributions to you. You don't have to take your required minimum distributions now until you're 72. It's no longer 70 and a half. But that's a different topic for another day. So you have your life insurance, your IRA. They both have beneficiary designations. Those assets go automatically to whoever you've designated as a beneficiary. We do not need to probate those assets. That's why it's so important that you check your beneficiary designation. The brokerage account, if there's no joint owner on it, that needs to go through probate. Your house, if there's no joint owner, that needs to go through probate. Any asset that's in your name that doesn't have a joint owner, does not have a beneficiary designation or a TOD designation, needs to be probated. So a lot of people don't realize that. So I explained to you what probate means, and I explained to you what types of assets need to go through probate. So the trend today is to try to avoid probate. It's not always practical or feasible to avoid probate, for instance, even like with the house. But if we can avoid probate, though, that's really where we want to go. There are certain instances when you absolutely must avoid probate. What are those instances? What if you have property outside of New York State? If you have property outside of New York State, like in Florida, you want to avoid probate because we would have to probate here and then we'd have to go probate there. Sounds like a Dr. Seuss book. If you have distant relatives, let's say you're an individual that was never married, never had kids, maybe you had no siblings, but if you did, maybe they're predeceased, and maybe there's nieces and nephews scattered around the country or even the world. And maybe you don't have a relationship with those people. We don't want to have to go through probate because probate will require us to contact those people and get them to sign papers, and that's cumbersome. Let's say you have a disabled beneficiary or minor beneficiaries where you want to set up trust to help protect these people. We don't want to be in the courts to do that. We want to avoid probate. So how do we avoid probate? By using a revocable trust. Revocable. That's very important that you pay attention to the word revocable. Revocable means that you can change it. You could do whatever you want with it. You could have complete access and control over those assets. What does a revocable trust look like? A revocable trust is nothing more than a piece of paper. You don't need to be rich to have a revocable trust. You don't need to have, any kind of extenuating circumstances. It's really an alternative planning approach to a last will and testament. And in fact, it says the same thing as your last will and testament. It's just that the formalities of a revocable trust are different. So let's say my only asset is a house. And we decide, let's say I have a house in New York and I have a house in Florida. And we decide that I want to avoid probate because it makes sense because of the house in Florida. So we're going to set up a revocable trust. We're going to draft it. You're going to sign it. It's a piece of paper. After we sign the revocable trust, we're going to take your two properties in Florida and in New York, and we're going to change the deed to those two properties, and we're going to put them in your revocable trust. Now, when you die, those properties avoid probate because anything inside of a revocable trust avoids probate. Isn't that great? So we saved you a lot of money, or we saved your family a lot of money in legal fees to probate your estate in 2 different states. And we shortened the period of time to administer your estate upon death because, quite frankly, after you die, as soon as somebody calls us, we could just simply draft the deeds out of the revocable trust to your beneficiaries. So a revocable trust is becoming more and more popular. We're using them a lot, especially with the change in circumstances that we're living in today. A revocable trust is very, very useful and has many, many reasons. Now, a revocable trust is not for everybody. So one of the things that I see people going to these hotel seminars. I see people going to restaurant seminars by other attorneys and financial advisors, and they're coming out with these revocable trust packages, and they don't need them. They don't need them. They don't have any. They don't fit into any of those categories that I was describing before, as to when you really must have a revocable trust. And you know, you could always make an argument for avoiding probate, but you don't always have to avoid probate. It's not always a necessity. So you really got to look at it from a facts and circumstances perspective. Each case stands on its own, right? The thing that a revocable trust does not do, and I hope you guys are taking notes because these are they're not basics, but these are the pitfalls in our practice. A revocable trust does not protect your assets. A lot of people have revocable trust and they think they've done their estate planning and that's the beginning and the end. It's not. Your revocable trust does not protect your house if you get sick and have to go into a nursing home. It does not protect your assets if you need home care. So unfortunately, I've been involved in many situations where children come to me after mom has gotten sick and they want to apply for Medicaid, and they say, Sal, mom has already done all of her planning. She saw an attorney years ago and they drafted a trust. And I said, well, let me see that trust. And I open it up, and right there on the front page, it says the Joe Jones Revocable Trust. And then I've got the challenging task of telling the children that mom didn't do asset protection planning. She didn't do long-term care planning. All she did was set up a trust to avoid probate and query whether she even needed that or not. That's going to take me into my next topic of asset protection planning. Before I do that, though, do we want to answer some questions on what I've already discussed?
Okay, so Sal, I do have a question that just came in for you. So the participant asks, does my revocable trust die with me when I die? What happens?
So that's a good question. And I'm delighted that you guys are asking these questions because everybody seems to have these types of questions. I went home last night and I happened to be speaking with my sister, and she says, I've been watching your weekly videos, because we do a weekly video on Thursdays at 2:00. If anybody wants to get onto Facebook today and hear my voice twice in one day, I don't know why you'd want to do that, but you know, we're doing that again today. And she said, you really need to draft my power of attorney. I'm saying, somebody's listening to me. And she said, and so if you draft my power of attorney and something happens to me, we'll be all set. I said, what are you talking about? She said, well, if I die, you've got the power of attorney and you can handle, you know, my assets. And I said, no, the power of attorney dies with you. And she said, I didn't know that. And I said, that's a very, you know, basic fundamental tenet. She said, but you didn't say that. So this is a very good question that you're asking. The revocable trust upon your death, it has to be administered. What do I mean by that? If there's a house, we have to go through the process of transferring the house to your beneficiaries. Once we administer all the assets of your revocable trust, then the trust terminates. It may terminate because everything's been distributed to your beneficiaries. It may terminate because it's going into another trust for your beneficiaries. But yes, the revocable trust terminates. So very important. When you have a revocable trust, now I'm going to start mixing and matching accounting principles. The tax identification number for your revocable trust is your Social Security number. You report the income from the revocable trust on your individual income tax return. But immediately upon death, that trust turns into a different entity during the administration process. So what's supposed to happen is a new tax ID number is supposed to be obtained for that trust during the administration process. Now, I've seen people do it all different ways. Sometimes there's no income for the trust after death, so they don't bother. Maybe it's only a house. And I always get the tax ID number because that's the right way of doing it. I hope that answered your question.
Oh, thank you so much, Sal. We have a couple more great questions that have just come in as well. So the next question is, what is an irrevocable trust? My father has one and he's still alive.
That's where we're headed next. So hopefully I will answer that question when we get into the next piece of what I'm about to lecture on.
Okay, great. So let me go to our next question then, as that one will be addressed shortly. My understanding is that 10 years of asset transfer is looked at when seeing if you could qualify for help with nursing homes. Please address.
So the look back period for nursing home care is 5 years. It's not 10 years. There's no 10-year look back period. So if you were to apply for a nursing home Medicaid, they look back at all of your assets for 5 years. And I'm going to talk about that a little bit more when we talk about the trust.
And Sal, would you also just be able to talk about how the POA can help there? So the question asker is also wanting to know about how the POA can access those records and to be able to make someone eligible for nursing home care, which you might address later on as well.
Well, it goes back to the discussion about the power of attorney. Any agent with a valid power of attorney, and again, there's a lot of mechanisms that go into, or there's a lot of technicalities that go into drafting a power of attorney that unfortunately are not followed often. I can't stress enough why it's so important to work with an elder law attorney. I mean, Sarah, you know that. You can support me in what I'm saying. The form is complicated. You need witnesses. So you really want to make sure that you've got a properly prepared and executed power of attorney. And then all of those bells and whistles that I'm talking about, because if your agent goes to a bank or a financial institution and wants to move your assets for Medicaid eligibility purposes, these banks have a lot of red tape. And if they're uncertain about the power of attorney or the authority granted or not granted, your agent's not going to be able to act. And what happens, and I probably should have said this before, is that in order for us to proceed with the planning, we're going to have to do a guardianship. And guardianships are the process of going to the courts. It's not fun. It's costly. It results in the court appointing somebody to handle your financial affairs, but we really don't want to go down that road. So
just to add on to what Sal said, so one very easy example of this with the powers of attorney in banks is that the New York State General Form just says all other matters. It doesn't specifically state that the agent, the person you appoint, can use the power of attorney to either add beneficiaries to your accounts if it's needed to avoid probate, or to change your beneficiaries if something becomes no longer in the family's best interest, like if someone becomes disabled and rather than having the asset go to that person, it would go to a supplemental needs trust or other planning vehicle that the attorney might be helping you with. And without these specific words like beneficiary designations in a power of attorney, which is a common provision that an elder law attorney would draft in, the bank might give you a hard time or say, I'm so sorry, but you're unable to complete this transaction because banks have gotten extraordinarily strict due to compliance. So like Sal said, it's so important to really have a strong, durable New York State power of attorney done by an elder law attorney with all the bells and whistles that kitchen sink, which is everything we as attorneys could think of and may have added in based upon our experience and our collaboration with our colleagues. Sal, we have another question for you if you have a moment to take another question.
Okay.
One of our participants says, I have a simple estate, no property outside of New York. I was told it's easier to make amendments to change a revocable trust than a will. Am I correct?
You know, I don't think one is easier than the other. You know, you could change your will at any time, and you can amend your revocable trust at any time. You know, we don't do a lot. It really comes down to working with the attorney that drafted the original document. If I drafted your last will and testament and you call me up and say you want to change the executor, I could just pull that document up on my computer, and assuming that there haven't been any monumental changes in the laws, I can make a quick change on my computer, reprint your will, and you just sign a new will. I don't do codicils on a regular basis. Codicils are amendments to your will. Now, if you come to me with your existing will that another attorney drafted, yeah, I could draft a codicil, but when all is said and done, the time it takes to draft a codicil, you know, you might need other documents. It just makes sense to kind of draft it over again. But yes, you can draft a codicil. It's not really, you know, a big deal. An amendment to your trust is the same thing. If I drafted your revocable trust, I could very easily draft an amendment to your trust. You could amend. I have people that come in once a year and amend their trust, which is a little ridiculous. But every year they've got something that they want to change or say differently. So it's fairly easy to amend all of this.
Thank you so much for that. So you have about another 20 minutes to continue
Good.
on with your remarks. Good. So I'm going to move on from the questions, but if anyone has questions, and I know that we're getting a lot of great questions in, Sal will either address what he can at the end of the program, or we'll connect you with Sal so he can answer them offline. Thank you so much for your questions.
Good. So let's talk now about what a lot of people are concerned about and what we do very often as elder law attorneys, and that's asset protection. And largely people want to protect their house. That seems to be one of the most important assets that people are concerned about. And that's where we get into talking about the irrevocable trust. Now, in my practice, I call the irrevocable trust a Medicaid trust because that's why we're drafting it. I spoke before about a revocable trust. So because I have a nice Irish accent, and people sometimes get confused with my accent, I don't like to say revocable and irrevocable because it gets confusing. So I say revocable and Medicaid trust. That's how I run my practice. People seem to like it. This is all about me educating you and you understanding what I have to say. And if I can make life easier for you by changing some of the terminology, that's what I do. So we're going to talk about a Medicaid trust now. That way you don't forget it. When we can all agree that we may get sick someday, and we can all agree that if we get sick someday, we could end up in a nursing home. If that happens, there's very limited ways to pay for the cost of that nursing home, which we know is expensive. You could pay for it yourself, and that's not planning. That's just, you use your money to pay for the cost of your care at the rate of, let's say, $15,000 a month. Listen, a lot of people don't realize that nursing homes are $15,000 a month. So keep that in mind. You could have long-term care insurance. A lot of people don't have long-term care insurance. A lot of people can't get it. A lot of people can't afford it. So those first two options aren't great options. Medicare only pays for the first 100 days in a nursing home. Maybe. I'm saying maybe because there are rules regarding that we won't get into now, but maybe. But at most, 100 days. So those three options aren't that great. The last option is Medicaid. So look at the four options that I just told you to pay for your long-term care. This is another point that I really want to drive home with you. If you get sick, if you need long-term care, you got to figure out how to pay for that care. Private, long-term care insurance, Medicare, Medicaid. Medicaid is going to become the option that you're probably going to want to go for. Not everybody. Some people might have long-term care insurance. Some people might have, a lot of assets and they're okay privately paying. But the majority of people that work with us want to set up a Medicaid trust to try to protect their assets, largely the house, in case someday later on they need to go into a nursing home. That's why we say plan today for tomorrow. My website is plan today for tomorrow. I'm not joking when I tell you plan today for tomorrow. We draft a lot of these trusts for people in their 60s and their 70s. I've done them for people in their 80s. I've even done them for people in their early 90s. There's a 5-year look-back period. I mentioned that before. So if you were to set up the Medicaid trust today and put your house into the Medicaid trust, you need to stay well for 5 years for nursing home care. If you could stay well for 5 years and not go into a nursing home, after those 5 years have elapsed, the asset that's in the Medicaid trust is no longer countable for Medicaid application purposes. So we could conceivably protect and preserve a lot of your assets if you do a Medicaid trust. Now, what does a Medicaid trust look like? It's irrevocable. And this is where you should go onto my website. I've got material, but also I have a folder. Usually when we're doing these in person, I have a folder to hand out to you. So we're going to try to figure out a way to get that to everybody. I've got information on this, but it's irrevocable. You normally would appoint one of your children as the trustee of the trust, and your children manage the trust, right? If there are brokerage account assets, financial assets in the trust, those assets can be invested, and you are entitled to the income from the trust. You cannot touch the principal from the trust. So if you put your house into the trust, you've got the right to live there. Nobody can kick you out. I know people worry about that. The house can be sold. Your daughter, as trustee, would sell the house, but she can't sell it without your consent. You don't need to worry about losing control over the house. There's a separate tax ID number for the trust, which is important to know. Some attorneys use your social security number. There's nothing wrong with that, but we use a separate tax ID number. You can change the beneficiaries of the trust. See, all these different things that I'm talking about are bells and whistles that a seasoned elder law attorney will draft for you. This is another illustration of why you need to work with an elder law attorney, because these trusts are extremely important and you can really mess them up without putting the proper powers. For instance, believe it or not, even though this trust is irrevocable, there's ways to revoke an irrevocable trust in New York State. But you've got to have certain bells and whistles. I hate to keep saying the same thing. You got to have certain mechanisms in the drafting of the trust. If you don't have those mechanisms built into the trust, you're not going to be able to revoke an irrevocable trust. I had that come up this morning with somebody. They drafted their mother drafted an irrevocable trust for reasons outside the scope of this discussion. They need to revoke it. They can't, because the attorney did not draft it properly. He did not put the mechanisms in the trust needed to be able to revoke the trust. They've got a problem now. So you don't play around with these trusts. You don't get these trusts drafted by a non-elder law attorney. You need to spend the money with an elder law attorney, do it the right way, and vet who you're working with. And that's why you should go on websites and look for reviews and do things like that. The Medicaid trust is becoming the bread and butter of our practice area. It's one of the few ways that we can help you plan well in advance. If we plan in advance, you're going to be a lot farther along than most other people when it comes to long-term care planning. I want to speak briefly about the look back period again. For nursing home care purposes, it's 5 years. But recently there was a change in the law. Home care used to be, there used to be no look back period for home care. So you could take all of your assets and transfer them to a loved one today and apply for Medicaid home care next month. Just recently, this month, they changed the rules regarding Medicaid to create a 2.5-year look back period. So another reason why we think the trust should be acted upon sooner rather than later is because now there's a 2.5-year look back period for home care. Home care used to be a safety valve for people that may have needed nursing home care or prior to needing nursing home care, but maybe would have made transfers during the last 5-year look back period. But now we can't necessarily say that anymore. We have a 2.5-year look back period to worry about. Now we're still vetting these changes. The Department of Health and the local Department of Social Services, they all have to weigh in on it. It was in the governor's budget, and now everybody's got to say their piece on it. So there's going to be a lot of planning that, develops because of this. But I want you to know that the playing field is getting more and more difficult. It's getting more and more difficult to do the planning that we once did on a very easy, regular basis. And the Medicaid trust is something that can really save the day. So we talked about basic documents, your advance directives. We talked about wills and revocable trust. We talked about protecting your assets with the Medicaid trust, which is extremely important. And if somebody like myself were to work with you, we sit down, we have a consult. Well, we're not going to be sitting down right now. We do everything telephonically, and we go through your facts and we try to figure out what you need. That brings me to my last point. I want everybody to feel comfortable, and this is what I've been lecturing on for the last couple of weeks. I want everybody to feel comfortable that we can develop an estate plan for you and attend to the execution of that estate plan remotely. Governor Cuomo signed certain executive orders over the last few weeks allowing for remote notarizations. In other words, what we're doing right now, if you're able to be on this video conference right now, then you're able to sign estate planning documents at home. We can notarize those documents remotely by video. We can witness them remotely by video, like the power of attorney and your last will and testament needs witnesses. And as long as we can do this and then exchange those documents, we can put together an estate plan and carry out your wishes. And so what I've been saying to people is that if you've got video capabilities and you've got a printer in your house, and even if you don't have a printer, it makes it more complicated, but we can mail you the documents. There is no reason in the world why you should not have an estate plan at this point. There is no reason why you should not be contacting an elder law attorney to do your estate planning and put yourself in a protective situation right now because of this crisis. But for the long term, put your affairs in order so that way your planning is done properly. And I said before, people come to me all the time and they say, Sal, I want to get my affairs in order. I'll say, what does that mean to you? And everybody wants to draft a will, but people don't realize that the will does nothing to protect your assets. A last will and testament takes effect when you die. It does not do anything for your asset protection if you need care. That's the Medicaid trust. So I wrote a nice article once and I called it the space between. You need to plan for the space between. The space between is the period from now until death. I joke around with my clients. I don't care so much about the dying part. You have a will. Even if you don't have a will, New York state law talks about how your assets should pass. Dying is easy. That's what I tell everybody. The hard part is protecting your assets during that space between, making sure that you got a good power of attorney, making sure that you drafted a Medicaid trust. If not, you have long-term care insurance, making sure that you deal with that space between. That's where all the mistakes are made. that's where all the problems occur. That's where all the headaches are. And that's where legal fees add up, right? For your family and your heirs. So I now want to take more questions because it's very important for me to answer people's questions rather than lecture. And I'm willing to stay on past 11 o'clock, but I don't know if we're allowed to do that. And I'm willing to answer questions by email later on. So Sarah, why don't you give me some more questions?
First question that came in is, can I place financial assets into the trust as well as real estate?
The answer is yes. So I had discussed that before. You could put financial assets. You get the income from those financial assets. That's what the trust does allow. But the answer is yes, you can put financial assets into the trust. Now, one of the things that I wanted to say before that I didn't say is that you don't put all of your assets into this trust. A lot of people will put their house and they'll put a portion of their assets into the trust. You put assets into the Medicaid trust that you're allocating for your kids that you don't need anymore. You don't put assets into the trust that you think you might need over your retirement years. So let's say you have a $500,000 brokerage account. You might sit down with me and or your financial advisor and say $300,000 goes into the trust. 200 you can keep in your name. That's a decision that you need to make on your own, and that's outside the scope of this discussion. But you don't put all of your assets into the trust. Pigs get fed, hogs get slaughtered. That's what I tell everybody.
All right. The next question that came in is for irrevocable trust. Sal, it's a tax question for your accounting hat. For irrevocable trust, does capital gains get recognized in the current or prior years, count as income to be distributed to the grantor of the trust?
So, I'm going to tell you what these trusts look like from a tax perspective. That's a loaded question because there are many different ways to tax a trust. It depends on how the trust is drafted. So I cannot answer your question because I don't know what type of trust you have, and I would have to read it to really give you an absolute answer. Trusts are taxed in about three. There are about three main ways of taxing trust. These Medicaid trusts are considered grantor trust. What that means is all of the income, everything that's going on inside the trust is put back on your individual income tax return. So you have to file a tax return for the Medicaid trust, but the Medicaid trust does not pay taxes. If there's income, interest, dividends, capital gains, it all goes on an informational statement that then gets put onto your individual income tax return. So you pay the taxes. The trust does not pay the taxes. But that is not a one-size-fits-all for all trust out there. So please don't take that and apply it across the board.
Okay, great. So question asker for the capital gains question. If you would like to address this in more detail, I'll connect you with Sal after the program and the two of you can speak offline. Just privately send the panelists your email address and we will forward it to Sal so he can address the question in more detail. Okay, so the next question, Sal, is going back to Medicaid trusts. With a Medicaid trust, can I put my rental property, which is still in my name, and upon sickness, does the deed transfer to my grandkids automatically?
So the answer is yes, you could put rental property into a Medicaid trust. You're entitled to the net rental income, so remember that. And the deed is transferred to the trust when you draft the trust, not upon your death. So when you draft the trust, you transfer the property to the trust, and then the trust owns the property, and then when the trust terminates, it passes to your heirs.
Okay, thank you, Sal. So the next question that came in is, where would we find information on what assets are looked at for Medicaid nursing home aid?
Well, I don't actually have an answer to that other than going on to the Department of Health website. We as attorneys know, almost all of your assets are accountable, but there are exclusions like IRAs.
In payout status. You have to take
in
your
payout
RMDs.
status.
Yep.
That's right. You know, there are a lot of exceptions to the asset rules, and probably the best place to go look for that, I think, Sarah, is the Department of Health website. I think they've got, you know,
And the
and then you
on our website. I believe we have
right.
a section in that book. So
And the
question
Medicaid
answer.
reference guide, the MARG, the Medicaid reference guide is also something people could find on the internet.
And we do have that section in the elder law Q&A available on our website.
Okay.
But as a rule of thumb, you should talk to an elder law attorney, and you should present a full list of assets, and to be ready to talk about other things that you may have forgotten were assets with that practitioner, because they really look at everything. Your entire picture, whether it's counted or not, goes in as part of that application. Sal, the next question is, can we move more assets into the irrevocable trust a year or two after it's been created?
The answer is yes, but you know, you know, a year or two, you got to remember, when you move new assets into the trust, it starts the 5-year look back period on those transfers. It doesn't reset the 5-year look back period for what's already gone into the trust, but it starts a new look back period for those second transfers. And depending on where we are in the initial look back period, I don't like to combine look back periods. And this gets into some technicalities about partial revocations and things like that. But what I sometimes do, like I had a client call me the other day, and they're 4 years into the look back period, and they, for some reason, they never transferred their financial assets into the trust. They only transferred their house. And I advised them to set up a new trust. We're going to set up a separate trust. I want to keep the financial assets separate now. I want the 5 years to run on the trust with the house in it. And I'm going to set up a separate trust for the financial assets. Could you combine them? Yeah. I don't think that's clean. I personally don't like to do it that way, because if you get sick during the second 5-year look back period, we've got to do a partial revocation of the trust, and we have to explain to DSS the facts and circumstances, and I don't want to get into that.
Okay, thank you, Sal. The next question that came in is, typically children or siblings serve as executors. What does one do when someone has no children or surviving siblings?
Well, you know, that's it's sometimes a difficult question, but you know, I always encourage people to search, you know, long and hard through their family. But if there's nobody, you can name anybody to be, you know, an executor. It could be a friend, it could be a bank, it could be a financial advisor, it could be an attorney, it could be an accountant. So you can name anybody, generally speaking, to be an executor. Ultimately, if you don't have somebody as an executor, the court would appoint the public administrator to handle your affairs, and you really don't want that to happen. So it would be good to have discussions with your trusted advisors, you know, et cetera.
Okay. So Sal, the next question that came in is, if I have a New York will drafted and have a provision for a percent to go to a minor, do I need to create a separate trust instrument for the minor's share, or can that be done under my will?
So that's a very important topic that we've been lecturing on a lot. If you're going to leave assets to a minor, you should absolutely have a minor's trust built into your will. Now, how we set that minor's trust up, we would need to have a discussion, because there's a lot of different ways to do that. But you definitely want to have a minor's trust set up under the terms of your will. When you have minors, though, that's when you might want to consider a revocable trust to avoid probate. Because if we've got to set the trust up, so I can draft a minor's trust in your will, but to make it all happen, we've got to go to court. And once the court gets involved with the minor's trust, it becomes very cumbersome. So we do recommend that you have a revocable trust when you have things being set up for minors or disabled beneficiaries. It will make life a lot easier. It is more expensive to draft. There are more action steps to take on your part and my part, but it's the better approach. It's better than having the last will and testament.
All right. Sal, so I think we've run out of time for our broadcast, but given the active response for questions, I just want to thank you so much for making your time available, and
Thank
Sarah
you.
for fielding all these. We didn't get to a few of them. We've captured the information that we need, and we're definitely going to follow up. I want to again share the screen and point out the seniorlawday.info website. Again, that's seniorlawday.info. If you have a question that did not get asked and answered today, there is an Ask Us button right here. You click on that button and you can connect with us. I've also got up on the screen the Elder Law Q&A, which is an excellent reference to many of the topics that Sal was talking about today. And finally, the video recording of today's presentation will be available on our website in two places. Every time we have a current webinar, we post the recording from the most recent one right at the top of the site. And actually, it's not actually at the top. It's at the top we have this wonderful PSA that was created by one of our collaborative members on how to wear a mask and gloves appropriately when you go grocery shopping. I highly recommend that you take a look at it. As you go down the site, you see the upcoming webinar. So today, as soon as we're done, I'm going to make sure the live registration link is available for the next program. And again, at the very top of the page, all of the 2020 webinars that we've been doing. We've started sometime in March, and I think we've got them planned out through June, as well as other videos from the collaborative are all posted here.